the police prosecutor admitted in court that he was asked to charge
this matter to court,
an accused to court who he knew fully well was not a suspect in the matter. He said that they could not find the suspect, and so they arrested his friends, and the authority is even reported in the papers, and the authority asked him to charge him to court. And so cases like that, you have so many irrelevant cases on your list.
So many of them.
What are the judges doing when you have this kind of case, Liberos? What will the judge say? Shouldn't that be
the matter was struck out?
Abuse?
The matter was struck out.
Eventually be struck out, but sometime would have lapsed.
But
you know,
the matter had,
and the man would have been detained in the meantime.
Yes, of course,
for a murder case that the prosecutor knew fully well that this was not the man we're looking for. He said the accused person was at large, and so we had to arrest his friends, and then we were asked to charge him to court
for murder.
And so, yes, and so you have so many of these cases pending in court.
Yeah.
And then also even matters that go for arbitration, you had resolved because some lawyers probably did not get
what they expected.
What they were expecting. If matter had been resolved at the arbitration level, you see them going back to court.
Yes.
And let's take, for example, even electoral matters. Imagine a case that had been decided by the Supreme Court. You see a lawyer still approach the Federal High Court asking for interpretation of that matter. So some of these cases just come up, and then you ask yourself, what is actually going on?
Time wasters.
Yes.
Yeah, Liberos, the issue of prison congestion. We saw the Chief Justice of Lagos, I think about a month ago, go to some places and actually release some people who had been awaiting trial forever. You know, she actually said that they should be freed. So the issue of prison congestion is a major problem in Nigeria. How is it that there's so many people in the prison awaiting trial, and because investigations take so long, people stay long in prison where they're not even supposed to be in the first place, and the ones who are supposed to be don't even have spaces?
Until the Supreme Court, in its wisdom, heard that there was nothing like holding charge in our criminal justice system. Before now, you see a situation where the police will arrest somebody, and then they will charge you on holding charge that they are still investigating the matter. And so, but since the law says you must charge the man to court within 48 hours, and the drafters of the law had expected that you would have concluded investigation before arresting the man. But in what happened here, you arrest even before investigating.
That's
and since the law says you must charge within 48 hours, you find them charging him to court on holding charge
without any evidence.
Without any evidence. That, okay, let's go and look for evidence against him. And the court said no.
What does the judge say in such cases?
The Supreme Court said no, you cannot. There's nothing like holding charge in our criminal justice system. And now what they do, you'll find situations where you arrest a man on Friday, you say, okay, let's just look for something to nail him and say the file, meaning the file to DPP. And so by Monday morning, they call them overnight cases. By Monday morning, you hurriedly pack all of them to the magistrate courts and charge them for whatever. And in some cases, these people, their relatives will not have even known where they are. And so they get to court, there is nobody to bail them, they are remanded in prison for minor offenses. And then they take log adjournment, and sometimes the file is nowhere to be found. And so for cases like that, some people have even advocated for minor offenses. What you do, dispose of these cases summarily, and then you can't even use alternative punishment like what you have in other jurisdictions, like what do you call it, where people are community service. You are asked to go do community service, go sweep the street and wear a tag that I was caught making phone calls while driving. And so when you see a young beautiful lady wearing a tag of, oh, I was making a call while driving and condemned to community service, 6 months community service by the magistrate court. The boat tag, you see them sweeping Ikorodu Road. A lot of people, this will deter a lot of people.
Indeed.
But a situation where you arrest the next thing because the law says you must charge to court within 48 hours, and then you rush to court, even without evidence, without proof.
Because they were making calls while driving.
Exactly. And so, that's what the situation will find ourselves here. And then you find the big criminals, when they are going to court, is celebrated because, you know, before the moment they are arrested, it's all over the news, it's in the radio, television. And so the day they are arraigning them, you have about 12 senior advocates, you know, waiting to apply for their bail. And then they go home scot-free.
And in some funny cases,
in some cases,
the advocates clash over who becomes the
exactly, because these are juicy briefs.
I mean,
imagine a matter in Abeokuta, a man stealing vegetable worth 5,000 naira. He was sentenced to 2 years imprisonment and an option of 10,000 naira fine. That was a week before the pension scam matter before Justice Yakubu in Abuja. So when you look at all of these cases, what's the encouragement for the ordinary Nigerian? And even the lawyers, sometimes you get frustrated.
Okay, let's ask Mr. Nzeakor then.
Yes.
In terms of this proposal this is going before the National Assembly.
Yes.
And while this is happening, do we expect to see, what is it we expect to see at the end of it?
One of the things we expect to see is a holistic reform that will bridge whatever gap we have between the criminal code and the penal code, because that thing has become a sore point in our judicial system. Because the penal code in the north, some offenses that have some level of punishment spelled out in the penal code are different. The same offense is different, has different penalty spelled out in the south, in the criminal code. And to that extent, there's no harmonization. If we operate under the same constitution, there has to be a harmony between the laws that operate in the north and the law that operate in the south.
But some states have Sharia law.
Some states have Sharia law based on what religion they profess. And those Sharia laws essentially are laws you have in the north. So, and then you, for any...
now, suppose those laws are at variance with what is in the Constitution.
Yes. Those laws are supposed to be invalid to the extent of such inconsistency.
Okay.
They are supposed to be invalid. But then you see and notice that some people prefer to go under the Sharia law if they feel that the provisions of the Sharia law favors them. Then, unlike those provisions that will be in the penal code system. And for instance, some criminal cases in the south that may attract up to 10 years imprisonment may attract just 6 months in the north. Some cases that will attract cutting off of limbs in the north would attract 3 months imprisonment in the south. So, but there is need to harmonize these laws. What we expect is that this reform system must touch the dichotomy between the north and the south with respect to administration of criminal justice system.
Quickly.
I beg your pardon. We've since been joined by the National Coordinator, Legal Defense and Assistance Project, Chino Obiago. Good morning.
Good morning.
Yeah, I'm sure the traffic on the expressway this morning is the cause of you coming so late, because we're going to be winding down very soon. But what is the position of the Legal Defense and Assistance Project on the reforms that are going on in the justice system now?
Well, we welcome the reforms going on, and as you mentioned, there are a number of wide-range reforms going on both at the federal and at state levels. And the key reforms are in the area of administration of criminal justice, the procedure. So the Administration of Criminal Justice Bill that was prepared in 2006 is now finding its way into the National Assembly. It has passed through the second reading. It is now, before the committee, and hopefully when they resume for next legislative year, it may be passed in the House of Reps. Well, having said that, the two states, Anambra and Lagos State, has already passed that into law and operation in those states. But there are still issues of implementation, even in the states where they are passed. So the reforms are welcome. It is long overdue. Those laws, the Criminal Procedure Code and the Criminal Procedure Act, were made in the 1940s with little or no amendments since then. Our criminal code and our penal code were made in 1914.